for this webinar on the U.S. Corporate Transparency Act. By being here, I think you've already recognized that although it's a piece of U.S. anti-money laundering legislation, it really reaches far and wide across borders, and it can very well touch your clients and owners wherever they're located in the world. Now, I do see that we have some U.S. partners on here as well. This presentation is, there's a lot of information in this law. It's very complex, and so it's designed to give you a very good overview and feel for the legislation without going into too much granular detail, but we do have a lot of detail behind it in a memoranda if you want that shared at the end of the presentation. So Lucy, can you go to the next slide, please? Okay, so our goal generally is that you come away with a really broad understanding of the types of entities that fall within the reporting requirement and what the reporting looks like for both companies and its beneficial owners. Also, the ongoing reporting obligations and the issues around internal policies that may need to be necessary for continued monitoring, and also various special considerations about how the law impacts particular industries and transactions, including industries like investment funds, real estate investment transactions, and also M&A transactions. Next slide, please. Okay, so we'll start getting a bit into the meat of the matter now. So what is the Corporate Transparency Act? It's a federal law that's designed to help law enforcement investigate potential money laundering. It requires beneficial owners of certain entities that meet the criteria to file identification information with the Financial Crimes Enforcement Network, which we call FinCEN. This law is really structured broadly to require, in essence, that the beneficial ownership reporting of essentially every entity unless it's exempt. And there are 23 very detailed potential exemptions that we will address broadly later on in the presentation. However, despite the exemptions, it is estimated that about 30 million entities worldwide may meet the criteria for becoming a reporting entity under the law. Next slide, please. Okay, so what the CTA is not. It is not a public database. It's specifically a database used for combating money laundering and criminal activity. And FinCEN's only allowed to disclose the information to prescribed actors and for certain purposes like state and federal law enforcement or national security, disclosing it to financial institutions that require the information to meet their own customary due diligence compliance requirements because they're already regulated entities within a regulatory environment. They can disclose the information to the Department of the Treasury, various other agencies that regulate U.S. financial institutions, and also certain foreign agencies that request the information through the proper federal channels for purposes of law enforcement, national security, or intelligence purposes. Next slide, please. Okay, so why might the law be relevant for your clients? Because merely doing business or registering to do business in the United States is enough to capture a foreign entity. And most exemptions, although there are many, are based on the company's U.S. operations and its U.S. regulatory status. And by their nature, most foreign entities will likely not meet this criteria unless they're, particularly large enterprises. Also, there are certain industries that will be much more heavily impacted, like players in global finance and global commerce, and including all manner of private investment funds and fund managers, family offices that do business around the world. Typically, they do them through privately held entities, and non-public foreign entities that do business in the U.S. or through U entities, including standard business operations. In addition, companies that are engaged in certain kinds of transactional activity, like M&A transactions that use special purpose vehicles that might come through the United States, will also be triggered and fall under the criteria. Also consider the various industries that are basically replete with the use of entities like partnerships or limited liability partners or limited liability companies, particularly in industries such as real estate investment transactions. So although the law has been subject to court challenges already, and at present at least one adverse ruling, which we will discuss towards the end of the webinar, FinCEN has construed the ruling very narrowly and continues to behave as if the law is currently in effect. Next slide, please. So before we go into the meat of the of the legislation will just give you a kind of an idea of how we might be able to assist your clients with considering if they fall within the ambit of this law. As an initial matter, we can help the companies essentially do an enterprise level review to identify whether or not they have the kind of entities in their corporate structure that conduct the operations or that otherwise might be caught by law even if they're not directly operating in the U.S. We can also help clients develop internal policies and governance practices to monitor compliance, including enterprise management systems to track reporting companies and beneficial ownership information changes, and also potentially having to update corporate policies. Next slide, please. And the specific granular things that we can also assist with are, once we identify the reporting companies, is that we can actually assist with doing the very deep analysis of equity and control structures that are needed to identify beneficial owners that are subject to reporting. We can advise the directors and officers about their responsibilities because there is potential criminal or civil penalties that can attach to officers and directors. And we can help implement corporate policies to help the clients and keep the clients up to date on FinCEN updates. And now I think I'd like to turn it over to Ian, who's going to start going into the details of the legislation.
Thanks, Noreen. And Lucy, if you can go to the next slide, please. So we're just going to spend a few minutes now just talking about what entities are subject and what individuals are further subject to the Corporate Transparency Act and the disclosure of information. So the Corporate Transparency Act, or the acronym CTA, it defines a reporting company. Next slide, please. And we'll just spend a moment on this definition. It defines a reporting company as a corporation, a limited liability company, or any other similar entity that's created by filing of a document with the Secretary of State or a similar office under the laws of the United States or an Indian tribe, or, and this is the second prong, it's formed under the laws of a foreign country and registered to do business in the United States by filing of a document with the Secretary of State or a law of a state or an Indian tribe. And the definition of a reporting company excludes a long list, as Noreen mentioned before, of exempt entities that we'll cover in a moment. But the key element in each prong of the definition is that a domestic company is, quote unquote, formed by the filing of a document with the Secretary of State. So the definition also includes any foreign entity, as I mentioned, that is registered to do business in the United States. And since nearly every state in the United States requires entities doing business in their jurisdiction to register by filing an application with the Secretary of State, this, as a result, this definition encompasses substantially every form of legal entity that's capable of doing business in the United States. So it's really a catch-all that an entity can only back out of if they meet one of the 23 exemptions. And we're not going to go through each one exhaustively, but I'll just touch on a few. Next slide, please. So you can see it in the background there, there's the list of the 23 exemptions. We won't try to read them all. But needless to say, what the exemptions are designed to do is not duplicate already existing rigorous regulatory oversight that exists amongst different industries or entities, including, and we'll just go with the images here, banks, large public companies, government agencies, government authorities, insurance companies. And then there's an interesting other exemption, which is, I think, exemption 23, but whatever the case, that speaks to large operating companies. And there it's a three-pronged test. And I'm highlighting this both to because it's probably germane to many of your clients, but it's also an indication of how nuanced the rule is in terms of whether or not to report. So the three prongs are it has to be an operating entity with more than 20 employees. It has to have a physical location in the United States, and it has to do more than 5 million in gross annual sales in the previous year.
Right, and
And
sorry, and those 20 employees also have to be in the United States.
thank you. Yep.
Yeah.
So what you're finding, and Noreen and I have come across this with one of our clients, is they have 19 employees. They do 20 million in revenue, but they're subject to this new reporting scheme. And if they went over 20 employees, let's say they went to 22 during the year, and then they reduce their headcount again to go below 19, they'd then be subject once again to the reporting regime. So it's really, the rules there are really designed to capture anything that is remotely perceived as opaque or outside the bounds of the specific exemptions.
Yeah, and Ian, I think that's a good example, the client, because it shows how the ongoing monitoring at the companies is necessary, because they can, even if they have an exemption, they could slip out of it.
That's right. So one would expect there's going to be a lot of analysis and interpretation of these exemptions, and we'll spend just a little bit of time towards the end talking about a couple of more as it relates to private funds and M&A transactions. But for now, let's go on and talk now about who are beneficial owners under the Corporate Transparency Act. So according to the CTA, an individual, and if you can go to the next slide, thank you, Lucy. An individual qualifies as a beneficial owner if they directly or indirectly have a significant ownership stake in the company. So this person, and again, this is an either or test. This person can either have a major influence on the reporting company's decisions and operations, or own at least 25% of the company shares, or have a similar level of control over the company's equity. And that sounds, if it sounds a little vague, it's intended to, because again, it's supposed to be a catch-all. Next slide, please. So the details that reporting companies need to include in a beneficial ownership information report, or BOI report, vary on the depending on the date that their business was established. So businesses registered or established in this year, 2024, must provide information regarding the business, its beneficial owners, its company applicants, including its owners and applicants' names, addresses, birthdays, and identification numbers, which include a license or a passport. However, if the business was established before that date, before this year, those companies can omit the information regarding the company applicants, but not the owners, beneficial owners themselves. So all reporting companies must provide their legal name. Oh, I'm sorry. Next slide, please.
Can I just jump in for 1 second with respect to that? If because I'm facing this with a client right now, if a company was filed prior to January 1, 2025, as Ian said, it has different filing requirements if it's formed this year. But keep in mind again that the formation alone is not the thing that triggers the filing requirement. It's also a registration to do business. So, and again, another client I have is this issue. They were formed in Delaware last year, and now this year they're within the next month they're registering to do business in New York State. That new registration to do business in New York State is a new trigger point that then subjects them to what happens, like how the law is applied with companies that are triggering the law in 2024.
That's great color. So moving on to the next slide, this information will look familiar to all of you in terms of the information that's required under the DOI. And all reporting companies, in addition, must provide their legal name and trademarks, their current U.S. address, which could either be its main business or for foreign companies, its U.S. operational location. And then critically, they're going to need to provide a taxpayer ID number and specify the jurisdiction that they were formed or registered in. And I'll end it for now by just saying that there's no annual reporting requirement on any of this. The initial filing requirement as of now is the only time you'll need to submit the required information, or of course, if there's an amendment or change to any of the information, which we'll touch on in a moment. And with that, I'll turn it back over to Noreen.
Oh, okay. Lucy, can you advance the slides, please? One more. Thank you. Okay, so when we basically have already somewhat covered this, but I'll just go into a little bit more granular detail. As Ian said, if you existed prior to January 2024, you actually have until January 1 of 2025 to make any of the filings. So you have, time, the clients have time to prepare, unless, as I said, they do something in 2024 that triggers a new sort of date by which the deadline is counted from. So if companies are formed during the year, they have 90 days. Anything that happens this year that triggers a filing, the companies have 90 days after the relevant action to make the filings. The commencing in January 2025, the filing timeline is compressed only 30 days after the entity formation or registration to do business. Next slide, please. Okay, so additionally, there's also the 30-day amendments rule, which means that if there's any change in either the reporting company information or the beneficial ownership information, the change also has to be reported within 30 days. For reporting companies, the critical information includes, what you would expect: the change of name, address, physical address, change of CEO, and also keep in mind that correcting errors in previous filings also need to be amended within 30 days of, the discovery of the error. Likewise, the changes in beneficial ownership information must be reported, including what you would expect: address, driver's license, and identity data for certain change in beneficial ownership, including, for example, the change of a status of a beneficial owner. Like, for example, if a minor is an owner, has an equity owner of the asset, and when they reach the age of majority, they now have to report as beneficial owners. Or, for example, the settling of an estate, when suddenly a beneficiary actually inherits the asset, then it triggers beneficial ownership filing. Next slide, please. Okay, so how to file. The filing process is electronic, as you would likely anticipate. FinCEN has developed a special beneficial ownership secure system beneficial ownership secure system, which they call BOSS, which is designed to receive, store, and maintain the beneficial ownership data. It's a cloud-based system that's designed to meet the high security standards set by the government. And although FinCEN is currently considering how it might manage paper filings. The filing certification also by the person who's actually making the filing must certify that it's true, correct, and complete. Next slide, please. And of course, as you would expect, there are civil and criminal penalties for both non-compliance and also filing false information. The penalties can apply to individuals and the reporting company itself, and also any other entities that might be culpable in the preparation process. Criminal penalties of up to $10,000 and 2 years in prison or both may apply, and there are also civil penalties that can be levied up to $500 a day. In addition, the person causing the failure, and including senior officers at the time of the failure, could also be held liable. However, good faith errors will not be deemed to be willfully fraudulent or false. Next slide, please. Okay, so I'm going to address now quickly some of the court challenges because it is relevant. The law is still being applied, but oops, sorry, I just moved my screen. There we go. But there are, but you know, the status of the law is being challenged. So the challenges are it's to its constitutionality, and there has been a federal court already in Alabama that's ruled that the CTA is unconstitutional. The court acknowledged that the CTA was designed to stop money laundering, tax avoidance, and other criminal activities, but it ruled that it's not sufficiently narrowly tailored to be within the congressional constitutional legislative powers that they have to regulate foreign affairs, national security, interstate commerce, or to impose taxes. The court also found that the CTA impinged on the powers that are typically vested in the states regarding the formation of corporations. Next slide, please. But nevertheless, that this ruling does not mean that the law has been overturned. The court specifically noted that it only applies to actual parties in the case. And although the Justice Department and the Department of Treasury have filed a notice of appeal last month, FinCEN has already issued a statement that narrowly construing the ruling and specifically saying that other than the particular individuals and entities who are the plaintiffs, the law is still in effect and that beneficial owners and reporting companies must still act in accordance with the regulations. However, this is not the only lawsuit. There have been more lawsuits filed in the last few weeks, including a recent one in Michigan that also challenges the law's constitutionality on the grounds of the Fourth Amendment, which is a prohibition against unreasonable searches and seizures, and the Fifth Amendment, protection against self-incrimination. It's interesting that these challenges are based on the premise that the law is requiring innocent people about whom there's really no basis to believe that they engage in criminal activity to essentially register in a criminal database. And so, however, although the law challenges continue, we're in a hiatus period where if your client takes an action, forms a company, or registers to do business, and we get to the 90-day point after that, and the law is still in effect and on the books, even though the court cases are pending, they will trigger the filing requirement. Or if they don't even have any activity during the year, but they exist by January 1, 2025, they will have triggered the filing requirement. So it's important to keep an eye on this and to be prepared to actually timely file because the penalties can be quite severe. Okay, I'll turn it back to Ian now to go into some of the special considerations for some of the practice areas we want to address.
Great, thank you. And Lucy, if you can go to the next slide, please. So let's just spend a few minutes as we wrap up, just talking, as Noreen said, about a couple of special considerations. One are fund structures. So fund managers need to consider the potential reporting and structural implications that may result from the CTA. So amongst other things, the fund managers need to analyze whether certain reporting obligations apply to entities within their fund structure and whether it's feasible to consider structural changes to simplify or minimize reporting obligations for the beneficial ownership information. So the reporting rules under BOI will also vary on the fund structure. So in cases that involve many reporting companies within a fund structure, that is entities that are created or registered by the U.S. Or in the U.S. by filing a document with the Secretary of State and don't otherwise meet an exemption, a fund manager might want to consider structuring alternatives to simplify or minimize the reporting burden associated with the beneficial ownership information reporting. And these requirements or these considerations will require fund managers to strike a balance between what's feasible and what's practical. And additionally, investors may want to consider structuring alternatives at the investor level, such as investments through exempt entities or in a manner consistent with non-reportable thresholds. So the implications of the Corporate Transparency Act are significant and can influence various aspects of a private fund's operations, including transactional due diligence, fund structuring, and investor relations. And as Noreen said, non-compliance can lead to substantial civil and criminal penalties. which makes it essential for private funds and their managers to really spend time looking at the CTA with their legal counsel to ensure they understand and meet the obligations. And I'll turn it now over to Noreen to spend a couple of minutes talking about considerations within M&A. You can go to the next slide.
Okay, so as briefly mentioned, and it's probably obvious to many of you, corporate transactions that involve special purpose vehicles in the United States will be caught under this legislation. M&A transactions present a complex matter if structured using a merger subsidiary, which will not be the surviving entity as well at the end of the transaction, because there's no guidance to address the question of whether an entity that was formed and then dissolved or merged into another entity prior to the date when you trigger the filing, which is at the moment 90 days, or which will become 30 days commencing in 2025, whether or not that entity would need to register with its beneficial owners with FinCEN. An argument can be made, of course, that if it's dissolved in the interim, it should not be reported because as of the filing due date, it no longer exists. And therefore, any reporting information about it is actually historical and not true on the filing date. But again, there's no guidance. On the other hand, SPVs formed by a strategic buyer might, in fact, be exempt under the large operating company exemption, depending on how the operations are organized. When we think about holding companies in these structures, if the holding company has no independent operations, it will likely not be exempt by its very nature of essentially not being allowed to take advantage of a subsidiary exemption that involves, because it's not a subsidiary, it's a holding company. And also, it would likely being a holding company would not meet one of the other exemptions like a large operating company, as we described earlier. So the process of going through an M&A transaction is actually going to involve a lot of analysis of the entities that are involved in actually structuring these deals and may, in fact, impact how deals are structured going forward. In addition to that, you have to think about the collateral documents and how they might be impacted. For example, employment agreements or operating agreements or shareholder agreements might need to be amended to require that the parties keep the company apprised. They have an obligation to keep the company apprised of changes of the beneficial ownership information on a timely basis. And of course, we'll be adding due diligence matters with respect to looking into the corporate policies and compliance of entities of targets that might trigger CTA reporting obligations. I guess next we have, I'll turn it back over to Ian now, who will put up with state law.
We'll just wrap by highlighting one other item, which is perhaps not surprisingly to those of us in the States, and you can go to the next slide, Lucy. Many states are already enacting their own legislation, which largely mirrors the Corporate Transparency Act. So this is, if this wasn't onerous enough, the states are now adding another layer of compliance to CTA by requiring entities and individuals at the state level, albeit with a later effective date, to report same or similar information in their databases. And when I say their databases, that's TBD. For instance, New York hasn't detailed exactly how or where the filings will take place, but they have set a date for 2026, and other states are following. Perhaps notably, Delaware hasn't enacted legislation as of yet, but one can anticipate that if it's not in the offing, it's being strongly considered. So in summation, the Corporate Transparency Act is going to dramatically change the way U.S. companies or companies that do business in the United States organize and govern themselves, because companies and their investors are going to have to account for this information and changes in this information in ways dramatically different than before.
So that's actually the end of the formal presentation. If